Good afternoon, everyone. My name is Jim Stang, and with me is John Lucas. We are attorneys at Pachulski, Stang, Zealand Jones, Bankruptcy Counsel to the Tort Claimants Committee. We're going to wait another minute or two before we get started so that other people can join. During the course of today's meeting, John will be monitoring the chat room, and we will do the best we can to answer questions that are of general application. And throughout the presentation today, we will remind you of the email address where you can send questions, as well as the website, which has some important information regarding claims in the case and other matters that may be of concern to you. John, could you give the email address of the website?
Yeah, it's BSA survivors at pszjlaw.com. That's P as in Paul, S as in Stang, Z as in Zebra, J as in Jones, LAW.com. And you know, and that's where you can send questions. And then also there's, you know, a whole assortment of information that's on our firm's website at www.tccbsa.com. Again, that's www.tccbsa.com.
And for those of you that did not have your pens out when John was doing that, Deborah Grassgreen, another partner of the Pachulski firm, has just posted both the website address and the email address so that you have it at your convenience. So today's topics that we intend to cover include the pending BSA plan of reorganization, that is the subject of the second amended plan, the TCC ideas about an alternative plan and how procedurally that might be presented to the court, the disclosure statement, which is up for hearing on May 19th. We'll talk about deadlines and subject matter of the disclosure statement objection. John will talk about the notices you've received from Boy Scouts regarding how to get the plan confirmation packages to you and or to your clients, and the voting mechanism that is currently being proposed. Next, we'll discuss the Hartford Insurance Company settlement that the mediators announced. And then finally, we will discuss the mediation that's upcoming next week in New York. So let's start with the plan.
Hey Jim, I want to just sort of jump in before we start, because I got a question from somebody, and they're wondering, why are they getting all these emails from Jason Amala with respect to what's going on? And so maybe, Jim, you could just sort of say a few words about
Sure.
Who Jason is and his firm, and how the TCC works with Jason's firm.
Sure. So Jason Amala is one of the attorneys at the Fowl Cochran firm out of Seattle that represents a committee member. Throughout these meetings, I have referred to Jason and other lawyers representing committee members as state court counsel. Jason has been working very, very hard to communicate with the broader plaintiff attorney groups to make you aware of options that you have regarding the disclosure statement, the objection, the ability to object to the disclosure statement. And he has worked very hard to provide a template as a suggestion for a disclosure statement objection. Jason works very closely with the TCC bankruptcy professionals, as do all of the other state court counsel. And he has taken it upon himself, I'll just note that in that sense, he is a volunteer, to communicate to all of you what you might want to do in representing individual survivors. Jason's emails have typically ended with, "I am not providing you legal advice." And he will also point out when his communications have in effect the endorsement of the TCC, or instances where we may have commented on what he is circulating. So in the latest template of a disclosure statement objection, we looked at it. We will have, the TCC will have its own objection, but we did provide Jason with comments, knowing what Jason was trying to communicate in the disclosure statement objection that I suspect he intends to file. So that's the relationship with Jason. His firm represents a committee member, and he has taken a particular interest at this stage of the case in the disclosure statement itself. John, does that cover the question?
It does. I mean, in short,
Well,
Jason's firms and clients' interests are sort of all aligned here, and he's trying to create a critical mass so that when we punch, at the next time we punch, it hits hard.
okay. So let's turn to the plan. You can find the plan documents at the Omni website. There's a separate tab that says plan documents. And you want to be looking, if you're going to look at it, the second amended plan. This plan has been called by the Boy Scouts a toggle plan. I don't consider that an apt description, but occasionally I lapse into using that word. So option A under their plan, which is the one they want to confirm, it's the one they want to have the court confirm, includes a contribution to a settlement trust by the Boy Scouts, currently valued by us at approximately $140 million, and an aspirational contribution by the local councils of $425 million, consisting of cash and property. The Boy Scout contribution is set forth in detail in the plan. They tell us which property they intend to contribute to the trust and how much cash. The local council number has not been committed to by the ad hoc committee of local councils. To the best of my knowledge, no local council has agreed to fund any part of that, what I call aspirational $425 million. This is the number that the Boy Scouts in their plan has proposed that the local councils put out. And one can speculate whether they would put that number out without having some sense that the local councils would in fact contribute that amount in total. But as I said, there is no commitment by any local council or local council representative to that number. If those two amounts were contributed, the Boy Scouts would propose confirming their plan that includes a discharge for them, which means that your claims against the Boy Scouts are determined by the plan, and a channeling injunction for the local councils, which means that your claims against the local councils would be in effect channeled or diverted to the settlement fund. And you would not be able to get a judgment against the local councils as to their non-insurance assets that would be enforceable. They are in effect getting a discharge in bankruptcy. That's what the plan proposes. The plan that's on file does not reflect the Hartford settlement for $650 million. We'll talk about our issues with the Hartford settlement in a few minutes. It is possible the plan will be amended again to reflect the Hartford settlement, because the Hartford settlement is conditioned upon releases, either voluntary or involuntary, of the local councils, and also the local council's consent. So that's the plan they want to confirm. $140 million from them and $425 million from the local councils, and now, most recently, a $650 million settlement with Hartford. The settlement trust would also obtain, under their proposed plan, an assignment of the insurance policies, both the policies that jointly cover the local councils and the Boy Scouts, and also the local council's individual policies. Because as we have said on prior calls, especially pre-72, the local councils, if they maintained insurance, maintained it in their own name. And post 72, there was a move towards joint policies. The plan does not identify any contribution from chartered organizations, be it Church of Latter-day Saints, the Methodists, Catholic dioceses, Catholic parishes, Jewish organizations, whoever you know was a sponsor or chartered organization. There is a provision for them to get a channeling injunction, much like the local councils would be getting, but there's no information that any chartered organization has made a proposal. There's no aspirational number by the Boy Scouts for the chartered organizations like there is for the local councils. But it is contemplated that there could be. When the money and property comes into the settlement trust, the Boy Scouts have proposed something we call TDPs, Trust Distribution Procedures. And these procedures are utilized to value your claim. So if your claim goes through the TDPs, which you're required to do under their Plan A, your claim will be assigned a value, say $1 million. The trust will take that claim, excuse me for a moment, and they will send it over to the insurance carrier that covers the claim and see if they can't reach a settlement of that claim. Alternatively, the settlement trust, not alternatively, but at the same time, the settlement trust will be litigating coverage issues with the carriers. It's up to the trustee as to how that litigation would proceed. But you would get a number out of these TDPs. And based on how much cash there is in the trust at that time, after reserves for running the trust and the TDP process, you would get a partial distribution on account of that claim. The TDPs are detailed in the plan and disclosure statement. We take great exception to aspects of the TDPs, but you should look at them and see if you can understand how they are meant to treat your client's claim. At the end of the day, if you don't like the result of the TDP, you have a litigation option, but you first have to go through the TDP process to be able to then resort to the courts.
And Jim, to be specific about that, what Jim also means by going through the TDP process is that you would have to submit sort of like a claim for reconsideration and submit $500 that is potentially non-refundable if they deny the reconsideration. And then in that event, you would be able to go out into the tort system. But your claim still out in the tort system is going to be sort of capped in a way by the value that's available under the trust. That's the way that I read the TDP.
Okay. So I want to make clear, you don't have to pay $500 to have your claim go through the TDP process, but if you don't like the number and you want to ask for reconsideration, there's a fee. And if you, after reconsideration, are still unhappy, you can go into the tort system, but the TDP process can cap your ultimate value through the litigation process. And remember, the BSA has been discharged. The local councils have been channeled. This is not a judgment that you get to then execute upon a piece of real property. So the Boy Scouts hope that survivors will vote for that plan. And the requirement is at a minimum 66% of those voting agree with it. But because the local councils who are not in bankruptcy will get a lot of advantages from this plan, that sounds like they've gone through a bankruptcy, right? They're assets that are still within their possession, that they are not contributing, are immune from judgment. It's like a bankruptcy. It requires more than 66%. How much more is the subject of debate? In our opinion, it is no less than 75% of the people voting. That's an important thing to remember, of the people voting, not 75% of the total constituency. It could be higher. 75% is the margin required in asbestos cases. That is statutory. There is no statutory provision for other kinds of mass torts. So people argue about the 75% being applicable in non-asbestos situations. So that's Plan A. If they don't get the votes in support of Plan A, and the court doesn't otherwise approve the plan, they will ask the court to approve Plan B. So Toggle suggests you have a choice. It's not a choice. They will go first with Plan A, see if they can get that confirmed. And if they can't, they will ask the court to confirm Plan B. Plan B is sometimes called, the word just a death option, if you will. You don't like Plan A, you're really not going to like Plan B. Plan B says the Boy Scouts will put in $140 million and they will assign their interest in the insurance policies, or its interest in the insurance policies, and everyone can go sue everybody else. You can go sue the local councils, you can go sue the chartered organizations. In states where you can directly sue the insurance companies, you can go sue the insurance companies. The only party protected is the Boy Scouts, who would be putting in $140 million and its interest in the insurance policies. We asked debtors' counsel if, say, a year after Plan B is confirmed and an insurance company wanted to settle all of its risks on all of its policies, could it cut that deal with the trust and bring that money in for the benefit of the survivors? And the answer was no. This is a Boy Scout only plan, one time only, one entity only. And there's no post-plan ability under Plan B to reach resolution with any other party and bring the benefit of that resolution to the survivor constituency as a whole. We saw the Boy Scout plan, and we thought that that option, those choices were really no choices at all. We'll get into it in a few minutes, but the contribution by the Boy Scouts is inadequate. The contribution by the local councils is woefully inadequate. And giving people the option, some 84,000 people, of go forth and sue didn't seem like much of a choice to us, especially when there was no ability to take the an insurance company or a local council or local councils and deliver to them a global settlement for the benefit of everyone. So we filed a motion with the Bankruptcy Court to allow the TCC to file its own reorganization plan. That motion is referred to as an exclusivity motion, because at the moment, the Boy Scouts have the exclusive right to file a reorganization plan. If you want to submit an alternative, you have to get court permission. Now, that's not a right that lasts forever, but it's a right they currently have. And they asked for the court to keep that right in place, and we challenged it by saying insufficient progress, and we have another way of going. So what is, oh, and by the way, the coalition ultimately joined in that motion in our objection to the exclusivity of the Boy Scouts, and filed their own objection about a week ago. So what is and we are in discussions with the coalition to come up with a plan term sheet that would represent our respective recommendations on how to proceed as an alternative to the Boy Scout Plan A, Plan B concept. Our proposal at a very high level looks a little bit like Plan B. Boy Scouts can put in their contribution. We might litigate how much they have to put in, but they'll put in whatever the court determines they have to put in. No other party gets the benefit of a channeling injunction unless We agree that the amount they contribute is adequate, and the court will confirm that plan. And then people can go forth and there will be a trust distribution procedure for those that don't want to litigate. And there will be the opportunity for survivors to litigate, be it against the local councils or the insurance companies or chartered organizations. But if a local council came to the trust a year into all that litigation and said, we're prepared now to settle globally for all of the risk we have for the survivors that have claims against us, our plan allows the trust to do that. It might require notice to the people whose claims are being affected, but the process will be there so that people aren't left on their own for years and years litigating their individual claims. We have a provision that the trust can propose a settlement that handles those segments, if you will, be it an insurance company or a local council. We specifically asked the Boy Scouts if their plan B provided for that, and we were told it did not. So they're really trying to force a choice upon you of taking what we consider to be inadequate value or go litigate. And we certainly appreciate the burdens of that litigation on your clients, given the nature of these claims. So that's the Boy Scout Plan A, Plan B. That's the Tort Claimants Committee's concept of an alternative. And we are working very hard with the coalition to reach agreement on principles of a plan. And on this major distinction that I'm making for you now, we have agreement with them that the trust should be able to bring a post-plan settlement to and resolve those claims for the benefit of survivors. There's a lot of minutia in behind that broad principle. We're working the best we can with the coalition to try to resolve differences. And that process is going on today, even. So the hearing, there is no hearing currently set for approval of the plan. These plan negotiations are all ongoing without a date set for confirmation. But what we do have is a hearing date on the disclosure statement. It is May 19th. The objection deadline is May 6th. And the purpose of the disclosure statement hearing is to determine if the Boy Scouts disclosure statement gives your clients enough information to make an informed vote on their plan. We have prepared an objection. It is being reviewed by the committee and the state court lawyers who represent those people. We will confer with other survivor groups, including the coalition, about their ideas for a disclosure statement objection. The materials that Jason Amala has been sending out touch upon some aspects of what is wrong with the disclosure statement. This is the focus that Jason wants to bring. That's why he's focused the way he is. There are lots of grounds for objections to this disclosure statement. They include inadequate information about the local council assets and the local council liabilities. I think that's a lot of what that template talks about. It includes inadequate information about the nature of the claims. State by state, they don't tell you state by state how many claims there are. The Boy Scouts do not tell you within the 1,000 claims against a given state how they break out according to the tiers. They don't adequately explain how they reach the conclusion that the claims are worth somewhere between $2 and $7 billion. They don't explain how they're going to fund this plan beyond the local council amount and their contribution, and certainly don't explain how the trust can be funded adequately given those dollar amounts. We have not seen a disclosure statement that explains why the Hartford Settlement is one that they entered into. It kind of goes on and on. So we're working on a TCC objection. I have no doubt the coalition is working on its objection. We will have some coordination with the coalition. And then there are the objections that other parties may put in. It would not surprise me to see objections from the insurance companies. The only party who will not be objecting, or parties who won't be objecting, are JP Morgan, who has reached a tentative deal with the Boy Scouts, and the committee representing non-abuse creditors, the trade, if you will. They've reached an agreement as well. But right now, we don't see beyond those two parties a lot of support for the Boy Scout plan. So, John, I'm just going to take a pause for a moment and see if there are any questions coming in that I should address on the plan and disclosure statement.
No, I think that we're in good shape, and there have been a handful of questions that I've been answering, and I think that we should move on. And you know, everybody, if there are other questions, you know, and move past something, you know, that doesn't mean you can't ask a question in the Q&A. So please go ahead and do that.
Okay, so John, I'm going to turn it over to you to explain the recent notices that people have been getting regarding how, if the court approves the plan, the disclosure statement, and sends the plan out for voting, how that's going to all be communicated to their client.
Yeah, hey, so someone just asked a question, so let me just jump in real quick. So
Okay.
The TCC will not be circulating a template of its objection before the May 6th deadline.
That is correct.
Yeah, so we will be filing our objection on May 6th at some point, and you know, but you know, the template that Jason Amela has been circulating, you know, is something that, you know, is a form of objection that he's been trying to get others to coalesce around.
It also has at the end a one-line joinder, and I appreciate that you haven't seen the objection that you're joining into, so you might want to do it after you've seen it, but I hope we've given you a flavor of what our objection would entail. It covers a lot of ground. One other thing I want to say, John, a lot of people are asking, how do I retain local Delaware counsel? Because the rules require that if I want to be heard by the court, I have to have associated counsel. We've put out a lot of names to folks. I think Jason has also done that, but it's been people that he's been good enough to convey it to you. I understand some of those firms are running out of steam, and I would just say to you, you don't have to have associated counsel to file your objection. And to the extent we can identify more Delaware lawyers who can associate with you, we'll get that word out. But we do recognize that some firms are saying we just have too many already. We're working on trying to identify more people that we think could capably be associate counsel. So John, go ahead. Why don't you talk about the plan package?
A couple weeks ago, BSA, through its solicitation agent, sent out notifications to law firms that represent survivors, asking them how they want to receive the plan solicitation materials. And so what they received was a thumb drive that listed all of the clients of that law firm. And there are three choices. These are my clients, and I will help facilitate the votes for them by way of a master ballot. Or these are my clients, and I want the ballots to go directly to them. Or I want some to go to them, I want some to go to me. And so that has been the process that's going on right now. And there's a deadline to respond to that notice of May 5th. And so, for example, a firm might have 20 clients, and the 20 clients are listed on the list, and they want to facilitate the votes for them and do a master ballot. Then you would just check the appropriate box and send back the client list in the manner which is described in the encrypted format that Omni or the solicitation agent is directing you to do. So, however, let's say that there are 20 clients on the client list, but you have 25 and they missed 5. Sometimes there are errors and that's why they missed them. But on the proof of claim, at the beginning of the proof of claim, there's this section and it asks the claimant, how do you want to be notified? By email, by phone, by US mail, by counsel. And you could pick all of them. And so if the counsel box was selected, then that claimant's name was put onto your client list. And so if the proof of claim has that box checked and it's not on there, and you want the client to be on your client list, you should add the name on there and do 2 things. Reference the proof of claim, maybe even attach the proof of claim and say, for John Doe 1, the box was checked. This should have been on the client list. And by the way, here's a copy of my engagement letter with the client. And you could redact out some of the pricing or other sensitive information as the directive notice sets you can, to show that you have a relationship with this particular claimant. And so that's sort of the process that's set up. And I mean, if there are other questions, people can ask them in the Q&A and I'll get back to them. Or you could also email the BSA survivors at pscjlaw.com and ask questions about the attorney directive notice.
John, what is the deadline for responding to that?
May 5.
Okay. And if you don't respond to that deadline, they will act in accordance with their notice, regardless of what the proof of claim says.
That is right. So if you don't respond and the 20 clients on the client list, they will instead send the ballot directly to the clients.
So the default is it goes to the client if the attorney does not respond to this notice.
Correct.
Okay.
Yeah. And one more thing, let me say, actually.
Let me just say that one more time. The default is that your client will get the solicitation materials to the address on the claim form, regardless of what they checked on the proof of claim form when they said, contact me, and there were 4 or 5 options. Okay, go ahead, John.
Yeah. So many of you have filed amended claims. Your original claim was filed on or before November 16th, which is the deadline to file claims. And then you amended the claim, let's say in December or January or February. And so on that client list, there's a column, and at the top it's titled, is the claim late filed? And if you filed an amendment after November 16th, there's a box checked there. And so it was just sort of administrative, I was told, and you should not be up in arms that your claim is late. They did that for all claims that were just filed after the bar date, even if they're timely by virtue of an amendment. So, and the other thing is that on that list, it might note that another law firm, and they give you the claim number, filed a claim on behalf of your client. There are, sometimes there are multiple law firms that might have filed a claim on behalf of your client in addition to the claim that your firm filed. And so we're trying to work out sort of that process right now. So for example, all these law firms will get sort of this directive notice and the ballots. And so if on behalf of your client, you vote to accept, and then the other firm votes to accept, there's no harm. Or you both vote to reject, there's no harm. But if one firm votes to accept and the other one votes to reject, and that vote matters in the outcome of the voting tabulation, then we're directing that BSA needs to run this to ground and determine which firm is the proper representative of the claimant and to determine which vote to count. And so that will be a part of the solicitation procedures, and we're trying to work that out with everybody, with the BSA right now.
Well, John, is it more accurate to say this is what we would object to if it's not provided for in the procedures?
Yes. That
they have to run it to ground. Right now, their position is we're ignoring the vote.
Well, they're ignoring the vote if there's a conflict that is not reconciled. Correct.
Right. And whether you want to contact the other law firm that's shown as your unintentional co-counsel, That's entirely up to you and how you want to handle that.
Yeah, and somebody's asking a question, well, can't I just amend the proof of claim and check the box that the attorney should be notified? Yes, you could, but I mean, we're sort of at a late stage here, and I would be concerned about sort of it getting picked up and connecting to the latter claim. I mean, because there's like 109,000 claims that are actually filed, and so there's a lot going on. My recommendation is to add the name to the list and then send in the engagement letter to show that you're authorized to act on behalf of the client. I think it's just sort of simple, it's straightforward, and it closes the loop.
Okay. Anything else, John?
Not right now, but we'll come back to something. Let's keep moving.
Okay. The next thing we wanted to talk about was the Hartford Settlement. The Hartford Settlement is set forth in the second mediators report, which was filed, I want to say, about 2 weeks ago. So you can find that at the Omni site in the general docket. The Hartford Settlement calls for $650 million to be paid on the effective date of the plan, which is when it goes into effect. And it goes to the settlement trust. It is not channeled to only the people who had claims during the Hartford years. It requires the consent of the local councils. It requires that the local councils be released, because Hartford's not going to leave them, not going to resolve it. It's not going to have that uncertainty without the local councils being protected. They have the option of seeking bankruptcy court approval of that settlement through a motion, and also seeking approval of it as part of the plan of reorganization. I don't know which they're going to opt. I don't know if they're going to opt for the plan approach, but in my experience doing other abuse cases and mass tort cases, it will be included in the plan. It's not currently in there. It's not in the disclosure statement. We think the Hartford Settlement is woefully inadequate. We object to it. The coalition objects to it. I don't know anyone who doesn't object to it outside of Hartford, the Boy Scouts, and I guess the local councils, because if they get a release, what do they care? It could be $5. It could be $3 billion. They just want their release. But it's 650. There are approximately 24,000 claims that fall within the Hartford year. But I want to make clear, the settlement does not channel that money to the 24,000 people. It doesn't, if you will, source it to them. It's for the benefit of the trust, both its administrative expenses and the payment of claims to the entire survivor population. So I'm sure John and I have done this, but if you'll allow me to just turn to my calculator, and I'm just going to take $650 million, it actually goes that high, and divide it by, let's do 84,000, which is the number of claimants. It's $7,700, folks, per person. And if we did that same calculation by 24,000, I should be able to do that in my head, it's about $27,000 a person. Now, you might say the settlement is what it is it's a good settlement. The fact it's not a lot per person is just too bad, because they've got good coverage defenses. Most of the claims are outside the statute of limitations. Whatever it isn't a good settlement for taking into consideration those factors. And we intend in our disclosure statement objection to highlight the additional information that you would want to have, that we think you'd want to have, to understand if the Hartford deal is good. And this isn't the time to object to the Hartford deal. This is a disclosure statement. All it's doing is putting in information that you might need to make an informed vote, or your client to make an informed vote. But as it stands, the TCC, and I expect the coalition, but I'm not going to put words in their mouths, will object to the Hartford settlement. We think that Hartford's exposure for its claims, taking into account a host of considerations, is multiples low. should be multiples greater. So that's where we are on the Hartford settlement. And last, we have a mediation scheduled for next week. It is, I believe, the 4th, 5th, and 6th, John? Is that right?
Yes.
Right. It is in New York. It was announced a day or two ago by the mediators. If you are a mediation party, you should have received the communication, but I don't think anyone who's an individual counsel representing individual claimants is actually a mediation party. It will be done by Zoom and in person, much like the last mediation session was conducted in Miami, but with increased vaccination and places opening up, there'll be more people in place. And the TCC will have attorneys there participating in the mediation, as well as on Zoom. So what's going to happen at the mediation? It's a little unclear because the agenda, at least as of the start of this call, I hadn't seen the agenda for the meeting. But I do know, in speaking with the mediators, that there will be a session between us and the Boy Scouts. There will be a session between us and the ad hoc local council committee. We have asked for a session with one of the carriers, and we will be in close communication with the coalition throughout the mediation. I would expect that they will have individual lawyers there as well. We are in negotiations with the Boy Scouts regarding what their contribution should be. There is pending a lawsuit by the committee against the Boy Scouts to determine whether their allegation of restricted assets is appropriate. They contend that because of donor restrictions, their charitable mission, and the properties that are vital or core to their mission, that very little is available to pay creditors. We have done an in-depth analysis of those allegations. We have written mediation briefs about it. The Boy Scouts have responded. The Boy Scouts, by the way, have the burden of proof on this issue. And we have contended that much, much more of their property is either unrestricted or was managed by them in a fashion that any restrictions are now unenforceable, because especially of commingling of cash and liquid investments. So we are discussing with them. There have been offers and counter offers. We do not have an agreement, and we're hoping that one can be achieved so that we can make that recommendation in our plan, or if we can resolve our differences with the Boy Scouts, possibly a joint plan. But I just want you to know we're in discussions about that. We cannot bind you as to those discussions, or if there was a resulting agreement. All we can do is make a recommendation. There is a lawsuit that we filed on the issue, but this will not get settled without the participation of all survivors having an opportunity to be heard. Second, we are in discussion with some carriers about how claims should be evaluated. No carrier has agreed that a certain process that yields a number will result in a payment of that number. But we are interested in hearing from them that if a certain process was applied to the evaluation of claims, that it would be credible enough for them to consider that those numbers are ones that should be paid in settlement. So it's, if you will, kind of a brainstorming session. We want to hear their ideas, because if we could reach an agreement for a fair and reasonable way of evaluating claims, we should propose it. It's very early in those discussions. There's been no agreement about any particular step in vetting a claim. Most of you have heard that the insurance companies are screaming fraud about the vast majority of claims. And we don't accept that. We don't come close to accepting that notion, but we want to have them put up or shut up to hear how they think this alleged fraud can be can be revealed. I'd be interesting to see what they say. They don't know how to respond to the tragic number of people who are abused, so they claim fraud. We've asked them, tell us how you think that should be investigated. So far, we haven't heard anything specific. The highlight for us of at least the first day of mediation will be a meeting that we will be having with all 250 counsels. At least they've been invited. This meeting has been something we have sought for a long time. The committee, through counsel and its accountants and financial advisors, Berkeley Research Group, have done a very, very deep dive on all of the assets of each local council. We have done an investigation of the types of claims that exist against each local council. And we did a presentation to the ad hoc local council committee several weeks ago on the procedures we went through to evaluate the local council's ability to pay. And not just in the aggregate, but by each local council. And we are advocating in our disclosure statement objection that this analysis be available to each survivor through a hyperlink in the disclosure statement, so that you could go to I live in Los Angeles, so I'll use that as the example, the Los Angeles local council, and see how many claims are against it, how those claims break out, the value of its real estate, whether based on our analysis, that real estate has a donor restriction, the appraised value of that property, if it's been appraised, and if it hasn't been appraised, how we have imputed value. You would see the membership direction of the local council. You would see our evaluation of how much they pay per scout to run each year, how much they have on hand for each scout, and other business analysis that will tell you if you litigated against the councils, this would be information pertinent to how much you might recover if your lawsuit was successful. We intend to make that presentation to the local councils. They've all been invited. We'll see how many come. We don't think the local councils have heard even the presentation that we made to their ad hoc committee. We attempted to present our individual analysis to 5 of the local councils, 3 of whom were not on the ad hoc committee, and they refused to participate in a meeting with us. But now this invitation has come from the mediators, and hopefully people will come, because at the end of the day, we believe that at least on a national basis, we know more about the local councils than even the Boy Scouts do. We have gotten to the point where we can tell you on any given camp how many other camps there are within a 5-mile, 10-mile, 15-mile radius. We can tell you what the utilization is of those camps. And we have identified in our presentation specific camps that they should surrender to the trust. Because when we made the presentation to the ad hoc committee, we did it from a percentage perspective. We said, you're only utilizing 45% of your camps, so you should give up 55% of them. And they challenged us and said, tell us which ones. So we took up that challenge, and we're telling them. Do we want those particular ones versus a different one? We came to the conclusion that for a local council that has 4 camps, given where they're located and what their utilization is, they can give up 2 or 3. Our goal to try to get an agreement is to demonstrate to them that they can survive and operate and perform the scout mission, but still put up a very substantial value, far in excess of the $425 million that the Boy Scouts would like them to put up. So if you couldn't tell, we're looking forward to making that presentation. And we hope that at the end of that presentation, that information will be digested and that local councils will have the ability to come together either through the Boy Scouts or through their ad hoc committee and negotiate a number that really reflects a settlement that would be fair to survivors. So that's what we've been doing since our last town hall. And John, I'm done with what I wanted to talk about. What are the things other people want to talk about?
You know, and I'm answering some things here too. But, you know, people are asking sort of general questions about, you know, what if I didn't file a claim, but I have a really good claim? What if I didn't file a claim against BSA in the bankruptcy case, but I have a really good claim against a local council or a chartered organization in a window state? Can I still expect to get a distribution from BSA's bankruptcy? And in my answer in the Q&A was, if you did not file a claim in BSA's bankruptcy, you will not receive any distribution at all. And that if you have a claim against a local council or a chartered organization, and their claims are released under the plan and the claims are channeled to the trust, then you will also be prevented from suing the local council, the chartered organization in the tort system. But if the plan is such that there isn't a channeling injunction that benefits the local council or the particular chartered organizations, and you didn't file a claim, then you would be free to pursue your claim on behalf of your client against the local council or the chartered organization and try to pursue a recovery in that way.
Now, John, I just want to say something, and I'm not trying to undercut what you said.
No.
If you filed it, you might file an objection to a plan that says, because you didn't file against BSA, if the plan says your claim against the local council is being channeled to a trust, but you didn't file a BSA claim, so you're out of luck, you could object to that and say, hey, I have rights against this local council, and my rights against this local council are being affected. But in terms of what the plan currently says, the BSA plan, I would not disagree with your conclusion.
You know, somebody else asked a question, Jim, just, you know, about the coalition supporting the TCC's efforts and the proposed plan. And I think Jim mentioned this earlier, and I'll let Jim speak more about it, but we are working with the coalition right now. And, you know, under the current context right now, I don't think that there are any survivors that support the current plan and framework right now. And we are trying to move forward hand in hand with the coalition to not just object to the current processes in place, but to insert what we think are better terms and for better treatment of survivor claims, whether it's in terms of settlement proposals with the either in any insurance company or chartered organization, or as Jim talked about a little earlier, local councils. Let me see. Somebody asked a question, Jim, about the camps and the real estate for the local councils. Who owns them? And you know, BSA has argued that they're protected and can't be liquidated. So maybe could you sort of talk about maybe a little bit about restrictions and maybe even a little bit about best interest? Sure.
So the Boy Scouts own their primary real estate assets are the 4 high adventure facilities: Seabase, Summit, the upper, I guess it's Minnesota they call it, or northern high adventure facility, and then Philmont. Those facilities have been appraised. One of our objections is that the appraisal should be made available through the disclosure statement hyperlink. But they have been appraised by the Boy Scouts. They contend that those assets are restricted. And part of our litigation against the Boy Scouts includes a question of whether or not those restrictions are, all those restrictions are enforceable. Your local camp is owned by the local council. And probably from what we know, has always been owned by the local council. It wasn't like it belonged to the Boy Scouts and they conveyed it at some point in time to the local council or had a last minute transfer in contemplation of bankruptcy. There are also Scout stores, and I guess they call them Scout centers. Most of the properties are owned by their respective local councils. Some are leased from governmental entities like the Forest Service or a park entity. We're not interested in getting those. We're really going after the fee interest. And as I said, the Boy Scouts have contended that these assets are restricted, and the local councils have asserted that many of their assets are restricted. And what we mean by restricted is that the donor or the seller put a restriction on the use of the property such that it is not available for creditors. So for example, if someone deeded a property and said, this is for a camp, and in the event it's not used as a camp by the Boy Scouts or the named local council, then it reverts back to me or my heirs. That is a kind of restriction that we look at closely to see if it's enforceable. And you all, if any of you have made donations to your favorite charity, oftentimes those are targeted appeals. Help us put a roof on our church or synagogue building, scholarships for certain people. Those kinds of restrictions are enforceable if written properly against creditors who are otherwise trying to take those funds. And we've looked at the local council restrictions, the real estate. We've looked at restrictions to a certain degree on their cash and investments, and we've certainly taken a very hard look at the Boy Scout restricted assets. And as I said, that's an issue of some pending litigation. Under the Bankruptcy Code, a debtor, in order to confirm a plan, must demonstrate that the value creditors are getting under the plan exceeds what creditors would get if the debtor was in a liquidation Chapter 7 bankruptcy. That is called the best interest test, sometimes called the minority rights test. And it's been called the minority rights test because each creditor has that right. And you can object to a plan on a creditor by creditor basis. It is not determined by the vote of survivors. So again, the test is the value I'm getting under the plan on my claim, does it exceed the amount I get if the debtor liquidated? So when we're going through the local council assets and the Boy Scout assets, we're looking at it from that perspective and for that purpose. Under Boy Scout governance documents, if the Boy Scouts were in a Chapter 7 bankruptcy, that Chapter 7 trustee would have the choice of renewing the annual charter. I can't imagine a bankruptcy trustee renewing a local council's annual charter. And under the governance documents, if that charter is not renewed, the local council assets come under the management of the Scouts. It is under the local council documents as we interpret them, those assets are liquidated for the benefit of the creditors in that local council. And then the balance, if there is any, goes to support scouting under the management of the Boy Scouts, but there is no scouting. So it goes, I think part of the benefit of scouting is the payment of creditors, including survivors. But you can imagine we have a difference of opinion about that with the Boy Scouts. The Boy Scouts contend that this minority rights test does not apply to them because under the Bankruptcy Code, this is not agreed to by everyone, but I would call it the majority view, that a company that is what the Bankruptcy Code calls non-moneyed cannot be put into a Chapter 7 bankruptcy. Some people equate that term non-moneyed with nonprofit. And I appreciate that the term nonprofit is perhaps emanates from the Internal Revenue Code. I'm just telling you how I believe most people interpret the term. And so the Boy Scouts have said, you can't run the analysis against us based on a hypothetical Chapter 7 because we can't be forced into a Chapter 7. The Boy Scouts could voluntarily file a Chapter 7. They're not going to. They could convert their Chapter 11 case to a Chapter 7. I don't envision them doing that. So because they can't be forced into one, this minority rights test doesn't apply. I have not found any authority that supports that position. And we certainly contend that that position is untenable and that the minority rights test applies. So either because the local councils are trying to get this channeling injunction and their value should be computed as part of the fairness of that, or because in a liquidation of the Boy Scouts, those local council assets ultimately go to pay creditors. We think the asset values are extremely important.
Yeah, it's sort of another way to sort of look at it is this best interest test is a measuring stick, and the debtors have to measure up. It's not an actual test where you have to actually liquidate somebody. It's just a measuring stick, and if it doesn't measure up, then you don't satisfy that condition, and that's a problem.
No, it's a problem because you can't confirm the plan.
Yes.
Right.
Hey, Jim, I got somebody's asking a question about sort of singling out the New York councils and New York chartered organizations and the closing of the window in August. And so I think what the question really is getting at is, well, are we going to know sort of what's going to happen with respect to the New York councils and the chartered organizations before the window closes? And I think the answer to that is no, you're not going to know what's going to happen. I think it's very unlikely that this plan would be confirmed. And so
this plan will, I'd be very surprised if this plan got confirmed by August 14th.
But what I think is really important, it sort of goes in response to this question, is that if you have claims, if your client has claims against a New York local council or a New York chartered organization, then you file lawsuits to preserve those claims. Because you need to do that before the window closes. And you know, in the event that there is some sort of channeling injunction, you need to have those claims preserved because you won't be able to pursue them outside the bankruptcy if they're channeled.
So just a little icing on that cake. People have said the TCC is urging folks to file lawsuits regardless of whether the lawsuits have any validity. That is not true. That is not true. Not every state is there are lots of issues about whether you have a good claim against somebody. Statute of limitations being one, obviously not applicable right now against New York or New Jersey or some others, California and some other places. If someone, we're not talking to the survivors today. And so all I'm saying is we are not advocating that anyone violate their Rule 11 or equivalent obligations to evaluate properly a claim. But I will tell you this. There are, John, how many claims are there against the councils in New York? Approximately 5,000?
Well, the Greater New York Council, there's at least 5,000, and that's an undercount. But
against the New York Local Council.
Only the Greater New York Local
Council. Okay, so when we go talk to the Greater New York Local Council on August 15th, and we say, you got a lot of claims against you. There were 5,000 Boy Scout claims filed that identified your council. And they come back and go, you know, you're asking us to put a lot of money in from our non-insurance assets. Because on the insurance side, they're arguably co-insureds. But you're asking us to give up camps, you're asking us to give up millions of dollars of money. We don't have 5,000 claims against us, Jim, as to those assets. We've got 500. And, you know, let's talk about 500, not about 5,000. If anyone's gotten a good answer to that question as to their non-insurance assets, please put the answer in the chat room, because I don't have one. You're barred by the statute of limitations. If you don't have a pending claim, well, I know some people would be within statute, but for those of you that would otherwise be barred but for the window, you're done. So we want people to remember that the filing of your Boy Scout proof of claim does not toll the statute of limitations against anyone except the Boy Scouts. And if you want to help us maximize the return from the New York Local Council, They're going to be focused on how many lawsuits there are against them when we hit them for a contribution outside of their insurance. And for people who have don't have windows, we'll say it again at the next survivor meeting. We are not advocating that people file lawsuits unless they are valid and have a likelihood of, and have the requisite likelihood of success.
Yeah, and the particular jurisdiction that governs the claim permits the filing of such claim. You know, there are some jurisdictions where the statute might have expired and nevertheless you can still file the lawsuit. And then there are other jurisdictions where there are strict prohibitions against that. And
Right.
so if you're not up to speed on that, you need to consult with a counsel from that jurisdiction to make sure.
So what you're hearing, folks, is help us, help you in a sense, by making sure that these local councils that have exposure have it in the form of a real litigation threat. And you're also hearing us being careful about ensuring that people who do bring the litigation, and I know we're speaking to the choir on this, you're all lawyers, or most of you are lawyers, they've got to be valid. We're not advocating lawsuits for the harassment purposes.
Yeah.
Let's call a hard stop at a quarter after,
Okay.
unless you've got a lot more questions.
I'm getting some more questions. So somebody has a question, says, you know, my client's statute doesn't run for a long time. You know, is there any benefit to initiating the suit now as opposed to later? And my response is, it makes sense to do it now because there could come a time when you're permanently enjoined under the plan from pursuing that claim against the non-debtor party, like the local council or the chartered organization. Plus, it gives us and you leverage against that local council or chartered organization to make a bigger contribution towards the plan.
Right. I'm going to flip the question. I know some of you live in states or clients have clients living in states where there's a possibility of window legislation. And you know, what happens if the plan is confirmed and then a window opens up? We are trying to address that in our discussions, internal discussions regarding the TCC plan and in discussions with the coalition. We know there are some states where the rumors are that such changes are imminent, literally in the next month or two. And we want to try to create a situation where people who want to litigate their claims to determine their value have the opportunity to do that, even if the window has not been enacted as of the date the plan is confirmed. We are sensitive to that and we are trying to address it.
So let me see here. Oh, let me see here. I mean, so some people are asking sort of questions about, you know, I don't have a lot of experience in this type of litigation, filing lawsuits for, you know, against local councils or chartered organizations, you know, but I have filed my proof of claim and preserved my claim with respect to BSA. What should I do? I think the response to that is, you know, you should probably reach out and consult with somebody who has experience in litigating childhood sexual abuse claims. And there are a lot of firms that are out there. It's not in our sort of platform or position here to be pointing out or recommending any firm, but I think that it's pretty easy to go out there and locate those firms that have a lot, that are sort of steeped in this type of practice.
I will point out, when we get that question from survivors, we tell them, do your internet search. We tell them to contact the state bar. I'm not endorsing anyone who's on the list, but there is a entity called the National Crime Victims Bar Association. NCVBA is their initials for their website. Again, I'm not endorsing anyone if they have an endorsement list, but those are some of the resources people can look to if you feel you want to associate with someone who has specific expertise.
You know, and the preliminary injunction that's in place in the Boy Scouts bankruptcy case now doesn't prevent you from filing your lawsuit against a local council or a chartered organization, but it prevents you from, so it allows you to file the claim, to preserve your claim for statute purposes and just preservation of the claim, but it does prevent you from prosecuting and carrying it forward. And so you would file it, serve it, and be done. Or it just sits idle for now until we figure out what's going to happen with the plan. Let me see here. Is Jim, do you think that the BSA will file another amended plan next week? I mean, I think the short answer to that is there's going to be another amended plan. And I expect that the disclosure statement deadline next week on the 6th will come, and there will be many objections. And I think that the debtor will be working hard to try to address the plan, to try to change the plan in response to some of those objections and what they say. I wouldn't be surprised if there are more than one plan in the coming months.
But I don't want to hear a collective sigh of relief that people do not have to file by May 6th. That is the deadline. And if the hearing gets continued after the objections are on file, whether that deadline gets reset or not, I can't speak to. So May 6th is the deadline, folks. Let's take one or two more questions and then ask people to revert to the website, to the email address, because I know folks have only so much time on a Friday afternoon.
Yeah, I mean, we have some other things here, but I think that we've covered a lot of this here, I think, in substance. But obviously, it was in the chat there. If you have a question, BSA survivors at pszjlaw.com. Send inquiries into there, and we will get back to you as quickly as we can. And also at www.tccbsa.com is our firm's website, where we have a whole host of information about the case. And then obviously, the docket and all the pleadings and stuff are available at Omni Agent's website. So.
Okay. Folks, thank you very much. And we will look forward to hearing from you through the email address. And we don't have a next town hall meeting set, but if the committee decides that it's time to update you from the mediation, we'll do that. And obviously, and I hope you feel that we try to be supportive throughout this process. We'll keep you updated periodically as the disclosure statement and plan process move forward. Okay. Thank you very much, folks.
Thank you, everybody.